The United States legal system is the main method for dispute resolution for citizens and non-citizens to resolve grievances under federal, state, and local law. The judge's job in this system is to apply the law and procedure to the litigation process. The jury, the most important factor in litigation, determines the facts of the case over the course of the litigation. The plaintiffs want the jury to accept what they say are the facts of the case, while the defendants want the jury to accept their statements as the real facts of the situation. Before the trial begins, there is a jury selection process. During the process, attorneys from both sides get to select jury members, and each side gets to automatically exclude a select number of jury members for any reason except for discriminatory purposes. This process of objecting to potential jury members is called voir dire. Because the outcome of the case and potentially a large amount of money being lost or gained and or rights being given and or taken away are in the hands of the jury, there has been a large increase in the use of nonverbal communication and analysis in the jury selection process. This is done in the hopes of finding individuals who are more likely to adopt a certain side's fact as the truth of the case. If a case is important enough, attorneys will use body language experts in assisting in selecting jury members. These experts use specific techniques in revealing jurors' opinions and biases in their verbal and nonverbal behaviors. Knowing how jurors actually feel about a topic is important because potential jurors may seek to deceive lawyers through their answers to questions. Studies have shown that from 60 to 65% of people's total communication occurs through nonverbal behavior. Dr. Jeffrey Frederick gives some insight in particular types of nonverbal communications jurors in general display. When people are anxious because of sensitivity to, let's say, particular subject matter, general nervousness, or a wish to deceive, they can leak their anxiety. There consist two types of nonverbal indicators attorneys look for in assessing jurors. The two are visual cues and auditory cues. An expert must be careful when evaluating any cue because no single cue or behavior is universally associated with lying or anxiety. The key to understanding jurors' body language lies in the deviations or breakdowns in their typical behavior. Some of the visual cues an expert uses during selection, they will pay attention to body movement, body posture, body orientation, inadvertent emblems, shrugs, eye contact, facial expressions, and microexpressions. Through discussing just one portion of one of these visual cues will allow us to discern how large of an impact nonverbal communication can have in the jury selection process. Body movement. In general, the more movement a potential juror exhibits, the greater the anxieties. These movements can involve the entire body. For example, shifting body posture or movement can be limited. For example, wringing hands or tapping fingers. But not all body movement is connected with anxiety. Rubbing hands together and squeezing them at the same time or tapping fingers on an object can reflect impatience. This impatience could suggest unfavorable reaction to the questions from the attorneys. Other signs of anxiety are termed adaptive movements, such as scratching one's head, pulling or twirling one's hair, or briefly touching one's face or picking at their clothing. Not all of these movements indicate anxiety. For example, scratching of the head may reflect uncertainty, particularly if the head is tilted. It is almost hard to imagine that jurors are giving away so much information without saying a word. As research and technology continue to grow, so will the wealth of knowledge that can be obtained through nonverbal cues in the jury selection process.